Now, that is one part of the history of Keshavananda Bharati. Now, factually, what Keshavananda Bharati was concerned with were three amendments: 24th Amendment, 25th Amendment, and 29th Amendment to the Constitution. Interestingly, by the 29th Amendment, the Kerala Land Reforms Act was put into the 9th schedule, which is a safe harbor. 9th schedule, as you all know, is a safe harbor. Of course, subsequently we will come to Minerva Mills, where 9th schedule, the court has made an inroad into 9th schedule, and I will try and explain that to you. But this judgment was put into 9th schedule, and the law as it then was that once a matter is put into the 9th schedule in terms of Article 31C, that enactment was outside the purview of judicial review. So the question arose as to whether, and if so, to what extent would the court go into and the vagaries of an enactment that is put into the 9th schedule. Now, the court, as you all know, ruled by a majority of 7:6. But now, in terms of the law that the Supreme Court has laid down, the majority minority doesn't matter, it's a 13-judgment. So, interestingly, I'll just read out a few expressions from that judgment, which according to me are exceedingly insightful into what the court's mind was into the basic structure doctrine, because as you would know, basic structure doctrine came to be expanded to include several other aspects, and I'll try and deal with them, time permitting, to the extent that's possible. So Justice Sikri, he was the Chief Justice then, he held that freedom of an individual has to be preserved for all times to come, and that it could not be amended out of existence. The view was that you cannot, by making or by exercising your power to amend the Constitution under 368, curtail the freedom of an individual. Now, it could be that you would read that here was a seed of Article 21 becoming a part of basic structure of the Constitution. But that expression came a little later. Then he went on, the Honorable Chief Justice went on to hold that the basic structure means the broad contours of the preamble. Now this is important, you may want to note down. Broad contours of the preamble made in order to carry out the basic objectives of the Constitution. Accordingly, he said that, well, I see Golaknath is not right. You can amend. And you can amend the Constitution. You can take away, but what you cannot do is to abridge or amend or modify what is the basic objective of the Constitution. Justices Shellart and Grover gave one view, holding that the preamble to the Constitution contains the clue to the fundamentals of the Constitution. And they went on to hold that balance and harmony between various parts of the Constitution forms a basic element. Now, what they were concerned with of different parts of the Constitution was essentially Part 3 and Part 4. Part 3, as we all know, deals with fundamental rights, Part 4 with directive principles. The debate was whether a law that gives effect to, or at least expresses that it is giving effect to, any part of the directive principles of state policy, can it be subservient to Part 3, or because it is trying to achieve a larger objective of doing a larger social or economic good, it is immune to the scrutiny of whether it violates or does not violate Part 3 of the Constitution. Justices Hegde and Mukherjee also gave their opinion on the same lines. The majority was Justice Sikri, Justice Shellart Grover, Justices Hegde and Mukherjee, Justice Jagannath Reddy, and of course Justice Khanna. his was the last view and the tipping view. And of course, as we all know, as the subsequent legal history has taught us, that judge perhaps suffered in a certain way. But that's for another day, we're not debating that here. Very interestingly, the expression of Justice Khanna is very important. He goes on to hold that it was not permissible to touch the foundation or to alter the basic institutional pattern of the Constitution. And he said the words amendment of the Constitution, in spite of the width of their sweep and in spite of their amplitude, could not have the effect of empowering the Parliament to destroy or abrogate the basic structure or framework of the Constitution. So the ratio, which ultimately there is a majority opinion in the report in the Supreme Court cases, but it was not signed by all the judges of the court. So there is a debate as to whether that represents the ratio or not. But the takeaway from the Keshwananda Bharati judgment are the following: it overruled I.C. Golaknath to hold that the Parliament can amend any part of the Constitution. But while amending the Constitution, what the Parliament cannot do is to take away or modify or tinker or obliterate in any manner what, according to the court, were the basic principles of the Constitution that we had given to ourselves. Some of the judges took the principles from the preamble, some from elsewhere, but here was a definite evolution. Post I.C. Golaknath was a theory, or evolution of the theory of basic structure. I will move on to now another interesting judgment in Minerva Mills, because it's the same series. Now, Minerva Mills was a 1980 decision. Minerva Mills, when it came to the Supreme Court, it questioned the 42nd, the very controversial 42nd Amendment to the Constitution. As you all know, 42nd Amendment followed by the 44th Amendment. I'm sure we've all read that history in our law classes. I don't think that's going to we're going to encounter that in your exam. But 42nd Amendment, once again, stung by the Parliament, stung by Keshwananda Bharati, wanted to undo Keshwananda Bharati. Very interesting. So they amended 31C, Article 31C of the Constitution. And they said that if a law declares that it is in furtherance of any of the principles laid down in Part 4, that law is immune to judicial review, notwithstanding anything contained in Article 13. In other words, the Parliament wanted to have the power to amend, enlarge, to include the power to do away or to amend any of the fundamental rights. So the debate now became as to whether the fundamental rights themselves are a part of basic structure. Are all of them a part of the basic structure? Are some of them a part of the basic structure? And if only some of them are, which are those fundamental rights which are part of the basic structure? Minerva Mills is reported as 1980, Volume 3, Supreme Court Cases 625. Justice Chandrachud, this is Y.V. Chandrachud, wrote the decision for the majority. And whenever you have time, if you do have time now or possibly later, post your exam, do please read that opinion. I have just picked up a few lines from his opinion so that you may want to use that in if you're encountered with a question that concerns Minerva Mills. And this is how he describes Keshwananda Bharati, and I think perhaps one of the most lucid, simple, and pregnant with meaning expressions from this score. So he says, theme song of majority decision in Keshwananda Bharati is amend as you may, even the solemn document which the founding fathers have committed to your care. For you know best the needs of your generation. But the Constitution is a precious heritage. Therefore, you cannot destroy its identity. It's a beautiful expression. It actually gives you the ratio of Keshwananda Bharati in about 3 or 4 lines. You cannot amend. You may amend as you may, but you cannot amend your precious heritage in a way that destroys its identity. The court in that matter went on to emphasize the importance of fundamental rights. Now, it is important as a student of law that Minerva Mills, of course, also had the benefit of several other judgments that came post Keshwananda, including Maneka Gandhi, emphasizing the importance of 14, 21, and 19. And the majority goes on to hold as follows. They say fundamental rights occupy a unique place in the lives of civilized societies and have been variously described in our judgments as transcendental, inalienable, primordial. For us, it has been said in Keshwananda Bharati, they constitute the arc of the Constitution. But they went on to qualify, lest you should feel that the entirety of Part 3 became a basic structure. They went on to qualify that within this essential framework that the forefathers have given us are 3 most important rights. They are 14, 19, and 21. That's why. And they go on to say, Articles 14 and 19 do not confer any fanciful rights. They confer rights which are elementary for the proper and effective functioning of a democracy. They are universally so regarded, as is evident from the Universal Declaration of Human Rights. And then it goes on to deal with how important they are. I do not wish to sort of detain you only on this. You may want to just note down to read paragraphs 73 and 74 of this judgment, which I think should give you a good insight into what this judgment went on to hold. But in 74, importantly, the court said 3 articles of our Constitution and only 3, mind you, only 3 stand between the heaven of freedom into which the Tagore wanted his country to awake and the abyss of unrestrained power. They are 14, 19, and 21. 31C remove 2 sides of that golden triangle, which affords to the people of this country as an assurance that the premise held forth by the preamble will be performed by ushering an egalitarian era through the discipline of fundamental rights, that is, without emasculation of the rights to liberty and equality, which alone can help preserve the dignity of the individual. So 14, 19, and 21 could invalidate a constitutional amendment. In other words, the violation of 14, 19, and 21 could invalidate a constitutional amendment, and they went on to declare 31C unconstitutional. Let's move on to S.R. Bomai. Oh, before that, Kihoto Bolovan. So the next judgment that I wish to discuss with you is Kihoto Bolovan in terms of chronology. Following Minerva Mills in 1980, Kyoto Holohan came in 1992. Kyoto Holohan questioned the validity, the vagaries of the 10th schedule of the Constitution. Now, 10th schedule of the Constitution, as we all know, is anti-defection. What was the premise of questioning? There are several grounds. Ground was that, look, in the 10th schedule, it is the Speaker of the Parliament or the Assembly who has been conferred the right to decide as to whether a member has or has not disqualified herself or himself, and therefore is required, unless the 2/3 or 1/3 is required to be disqualified. The premise was that, look, Speaker is politically appointed, and as a politically appointed person, how can he be the judge? And if he cannot be a judge, then can his decision of disqualifying anybody be subject to judicial review? So various provisions of 10th schedule came to be questioned. In fact, 10th schedule was questioned in its entirety. To say you cannot have this, it is for the court to decide this, not for the Speaker. The court concerned itself with not just whether the 10th schedule is valid or not, but a very interesting question, and that is what perhaps you may want to note and remember. And that is the principle of severability in the context of the vagaries of the entire 10th schedule. Could you take out a provision of the 10th schedule and say, well, this is bad, the rest is fine? Or do you have to invalidate the entire 10th schedule? Now, in Kyoto Holohan, the court went on to lay down the following principles. Judicial review is a part of basic structure. It was reiterated. And therefore, that part of the 10th schedule, which bars the courts to review the decision of the Speaker, is bad. And that was clause 7 of the 10th schedule. They said that is not permissible. It is not permissible for the Parliament to amend the Constitution so as to take away from the court the power of review of any action. The second question that the court concerned itself with is, if it has the power of judicial review, is there a limit to that review, or is it a full-scale review of any decision that is given by the Speaker? The court goes on to hold that the Speaker, while functioning under the 10th schedule and deciding on the disqualification of any member of the Parliament or Assembly, is acting as the tribunal. So the second principle that you need to remember is the Speaker is a tribunal while functioning under the 10th schedule. The third question. So if the Speaker is a tribunal and the court has the power of judicial review, to what extent can the court look into the decision of the Speaker? And the court said, well, it can't be a review of the evidence, it can't be a review of the facts as were before the Speaker. For he is the judge within the 10th schedule. So we will look at his decision from a very, very limited perspective as to whether or not it conforms to the principles of natural justice. Whether or not the speaker had applied his or her mind to the facts and come to a decision. We will not do a full-scale review of every part, of every aspect of the decision that the speaker has rendered. The important paragraphs in Kyoto Holo are 109, in fact 77, 78, 109, 111 and 119. Then came before the court another interesting matter. And that is S.R. Bomai. So now we are past Keshwanand Bharti, we are past Minerva Mills, we are past Kyoto Holo. Now came the question of a proclamation issued by the president under 356, and whether the Supreme Court, or for that matter High Court, can review, exercising judicial review, which is a part of the basic structure by now, can review the decision of the president, making a proclamation under 356. 356, as you all know, is exercisable on the aid and advice of the Council of Ministers in terms of Article 74. So the question was essentially as to while reviewing, is the court entering into a political thicket? While reviewing the decision of the president, is the court willingly or unwillingly entering into a political controversy? And if it is permissible for it to do a review, to what extent can it do a review? Once again, like Kyoto Holo speaker, here it was the president. And very importantly, whether it can invalidate. Can it invalidate the proclamation? And if so, on what grounds? The court went on to hold that because that judicial review is a part of the basic structure, the court can review a proclamation issued under 356. But the review is limited to examining whether there was any material, sufficiency of which the court will not look into, whether there was any material before the president on the basis of which the president had exercised on aid and advice of the Council of Ministers the power under 356 of the Constitution. And it reversed the burden, very importantly. That's the best part of Mumai. It said when a proclamation is questioned and a prima facie case is made out by the petitioner, it is for the union government to justify the action of proclamation. Very, very important. Normally the court would say, petitioner, you prove. You prove your case. It is not for the respondent. The respondent can keep quiet. It is for the petitioner to make good. But given the situation where the president is exercising the power under 356, the court said, if the petitioner makes out a prima facie case, it is for the union government to then justify its decision by placing before the court the material, sufficiency of which the court is not getting into, but the existence of the material that was before the president before issuing the proclamation under 356. The important paragraphs of this judgment you may want to note are 31 to 35 and 40 to 60. Of course, it's a long judgment, but I don't know whether you'll have the time to go through all of it. But if you just read these paragraphs, they should be they should hold you in good stead if you come across a question and I'm not setting any. So please, I am far away from it. So therefore, please don't treat this as some kind of an inside information of what is coming your way in your examination. But now we move on to another judgment of this court, which is a part of your syllabus, and which is Supreme Court Advocates on Record Association versus Union of India. This is reported as 2016 5 SEC page 1. And this case concerns the validity of the 99th amendment made in 2014. 99th constitutional amendment made in 2014. What did the 99th amendment do? It gave life to what is being hotly debated today, the NJAC. NJAC came about by way of an act, which is the National Judicial Appointments Commission Act 2014. So both the constitutional validity of the 99th constitutional amendment and of the NJAC Act was questioned before the Supreme Court. Now we have traveled in the legal history, we have traveled from I.C. Golaknath up to 2016, and we have various parts becoming a part of the basic structure. Initially, what is set out as the basic principles in the preamble, Keshwanand Bharti did not enumerate every single part of the basic structure. He said it is to be evolved over time. Then came the subsequent developments. Now you had another situation. So judicial review is a part of the basic structure. But what about judicial appointments? Are they also a part of the basic structure? In the sense that can the Parliament by law make it inroad into judicial appointments? And whether that inroad is blocked by the principle or the doctrine or basic structure or not. Now here, the court very interestingly went into the issue of the fact that you have a separation of powers within the Constitution. And that separation of power separates judiciary from executive, from parliament, or from legislative. And the court said it is this separation of powers which is the lifeblood of the Constitution. I'll read to you because it's a very important judgment, and possibly I have a hunch that you will encounter this because given the debate that is going on currently. So allow me to devote some time to this judgment. I will read to you a couple of passages from this judgment. So this is Keher's view, para 126. It is clear that the issue canvassed by the learned AG was finally answered by the 9-judge bench which disposed of the second judge's case, that is 93, 4 SCC 441, the consultation judgment. What does consultation mean? Consultation doesn't mean merely soliciting views, but those views have a value and that is the binding on you. That's the 93, 4 SCC Supreme Court. I'm sure you've seen that. By holding that if the power of appointment of judges was left to the executive, the same would breach the principle of the independence of the judiciary, and also conversely that providing safeguards after the appointment of a judge to the higher judiciary would not be sufficient to secure independence of the judiciary. In the above view of the matter, it is necessary to conclude that the manner of selection and appointment of judges to the higher judiciary is an integral component of the independence of the judiciary. Independence, separation of powers, basic structure. So everything getting anchored into that principle. Another interesting passage is a very interesting argument was made before the court that the Act was passed, both the Amendment Act and the NDAC Act was passed with minimal dissidence in the Parliament. So the question was, it is actually reflecting near complete Parliament's wisdom, with a very few absentees or dissents. And in para 296, the court held that the scope of judicial review with reference to a constitutional amendment and or an ordinary legislation, whether enacted by Parliament or a state legislature, cannot vary so as to adopt different standards by taking into consideration the strength of the members of the legislature concerned, which had approved and passed the bill concerned. If a constitutional amendment breaches the core of the constitution or destroys its basic or essential features in a manner which was patently unconstitutional, it would have crossed over the forbidden territory. Now, please note a few paragraphs that you may want to look at it, because I think this is an important judgment for you. 296, I have already told you, 300, 308, 346, and very importantly, 380. I am now reading to you a few lines from 380. We have given our thoughtful consideration to the above contentions, the basic structure of the Constitution. Presently, inter alia includes the supremacy of the Constitution, the republican and democratic form of the government, the federal character of distribution of powers, secularism, separation of powers between the legislature, the executive, and the judiciary, and independence of the judiciary. So, independence of the judiciary now gets into the Keshwananda stream and becomes a part of the basic structure. Another passage which is very instructive in this very paragraph 380 is, when a plea is advanced raising a challenge on the basis of the violation of the basic structure with reference to the independence of the judiciary, its rightful understanding is and has to be that articles, now this is very important, articles 12, 36 and 50 on the one hand, 12 definition of state, 36 and 50 are on the one hand, and articles 124, 217 and 222 are on the other hand, constitute the basis thereof. Clearly, the basic structure is truly a set of fundamental foundational principles drawn from the provisions of the Constitution itself. These are not fanciful principles carved out by the judiciary at its own, and then goes on to conclude as that the amendment and the act was unconstitutional. Well, several people have commented about this judgment, and it's not their liking, but we are not here to get in that. That takes me, I have a long line, but I think I'm taken more time than I was slotted, so I'll take 10 more minutes of your time if you permit. So that takes me to Madras Bar, because that's in the same vein. Madras Bar is reported as 2021. I noted the SEC citation, I have SEC online citation. I'm sure you will be able to find the SEC citation. It's a 2021 judgment. Now, by Madras Bar, we are through with the judgment in SCAORA, the third SCAORA. So you have independence of the judiciary becoming a part of the basic structure. But the stream is continuing. Now in Madras Bar, the question was whether sections 12 and 13 of the Tribunal Reforms, Ordinance 2021, which merged various tribunals, and 184 and 186 of the Finance Act, as amended by the Tribunal Reforms Ordinance, are valid. Once again, a familiar debate followed: separation of powers, judicial review, independence of the judiciary. But in my understanding, you would want to go over paragraph 44 of the judgment. That's the heart of the judgment. And it lays down 4 principles, which I am now reading to you. The effect of the judgment of the court can be nullified. Now, this is very important, because what was this doing? What were these enactments doing? Once again, they were trying to undo a judgment. And therefore, the question before the court was, can the parliament undo a judgment of the court? And whether an act which undoes a judgment is valid, and can be questioned on the basis that it is undoing a judgment of the court. The principles that laid down by the court are: the effect of the judgments of the court can be nullified by a legislative act, removing, now this is very important, please pay attention because it's very, very important. You will find the court is walking a very thin line here. And depending, if you sort of flip a few words here or there, you are in a forbidden territory. So court says the effect of the judgments of the court can be nullified by a legislative act, removing the basis of the judgment. Such law can be retrospective. Retrospective amendment should be reasonable and not arbitrary, and must not be violative of the fundamental rights guaranteed under the Constitution. Let's understand for ourselves what does it mean. So suppose there is a judgment interpreting, say, section 12 of a given act, and holding some part of that section to be ultra vires. If the parliament amends section 12 by removing the offending part, it's fine. So long as the amended provision complies with part 3. What the parliament cannot do is to say, well, we are reaffirming section 12 and the judgment is wrong. I hope I'm making myself clear. So the next principle, the test for determining the validity of a violating legislation is that the judgment pointing out the defect would not have been passed. So this is the test. The judgment would not have been passed by the court if the altered position as sought to be brought in by the validating statute existed before the court at the time of rendering the judgment. Meaning thereby, if this amended provision was before the court would not have invalidated any part of it. That's the test. Nullification of mandamus by enactment would be impermissible. So you cannot nullify a judgment, but you can remove the basis of its invalidity. Please appreciate the difference between the two. Removing the basis of its invalidity means that if the amended provision was before the court, the court would not have invalidated it. That is permissible, but it is not permissible to overrule that judgment. And then the court goes on to justify it as follows: say, transgression of constitutional limitations and intrusion into the judicial power by the legislature is violative of the principles of separation of powers, the rule of law, and of Article 14 of the Constitution. I am sure by now you are all fed up of me, and you would yourself say these are all part of the disease. Last judgment that I felt that I must tell you, and which is another landmark, once again tying in to the principle of judicial review forming part of the basic structure, is L. Chandra Kumar. L. Chandra Kumar's history was Sampath Kumar, which said, well, the Administrative Tribunals Act is fine. it says that no court can look into the orders passed by a CAT or a SAT. Then came H. Chandra Kumar questioning the correctness of Sampak Kumar. And the court held that no act, the parliament cannot enact any legislation that takes away the power of the High Court under 226 or of the Supreme Court under 32 or 136. And of course, soon enough, the Act was amended, and then what followed is history. I had also on my plate a couple of judgments which are very close to my heart, because I'm also I'm a practitioner of public law and commercial law. So unless I speak about some commercial law, I don't think I would have satisfied my conscience. So I think one judgment that stands out, there are two judgments that stand out in your list on these issues and are, I think, Sang-Yong and a few IBC judgments. So I'll summarize all of them actually. I'll just give the principles rather than give you the judgments. Sang-Yong is a judgment of the Supreme Court given in 2019 concerning section 34 of the Arbitration and Conciliation Act. The question before the court was section 34 had undergone amendment in 2015. The question was, what are the powers of the court under section 34 when an arbitral award is challenged? What is meant by patent illegality? What is meant by perversity? What is the test? Are they expressions which are so deceptively subjective that any judge who finds perverse and somebody else who says it is not? Somebody would say it's apparently illegal. Why? Because it violates some provision of CPC. Let's say list of witnesses not filed and validating the award. In Sang-Yong, the court reiterating the principles laid down in the earlier judgments held that patent illegality is not just violation of any law, but violation of such laws as are fundamental to our system of laws. So let's say suppose some provision of the Evidence Act is violated. The witness was put a question in cross-examination which ought not to have been put in the cross-examination. Leading question put in examination in chief, let's say, violation. That's not good enough. It must be a fundamental policy of Indian law. So that's patent illegality. What is perversity? Perversity is when the tribunal ignores a material evidence that, in keeping with the principle of judicial functioning, no tribunal could have ignored. But in ignoring that material evidence or rewriting the terms of a contract, the arbitral tribunal has rendered an award. That award can be interfered with under section 34. As far as IBC is concerned, there are a number of judgments that are there in your list. But I think the principles are more important, and you may just sort of keep in mind the principles and use them in case you're confronted. So the principles are as follows. The framework of IBC, I don't know how many of you are familiar with, is pithily the following. In terms of section 7 of the IBC, a financial creditor, which is a defined term, can petition the NCLT for initiating corporate insolvency resolution process against a corporate debtor. Who is a financial creditor? To whom a financial debt is owed. What is a financial debt? Section 5(8) of the IBC defines a financial debt. An operational creditor can similarly invoke the machinery of the IBC through Section 9. Who is an operational creditor? To whom an operational debt is owed. What is an operational debt? Any debt that is due against provision of goods or services. And in Section 10, the corporate debtor itself can trigger the process on its own. Voluntary voluntary insolvency resolution. Now, the IBC has led to a mushrooming of attachments, and some of them are decided here. The principles which have been written down are the following. In case of a financial debt, the NCLT has no discretion except to admit the petition if there is a debt which is presently due and there is a default. So, in case of a financial debt, the NCLT is bound to initiate corporate insolvency resolution process if it finds that there is a debt, it is due, and there is a default. In case of an operational debt, that is against provision of goods or services, NCLT has the discretion to look into the facts to find out whether there is a dispute of liability, and a dispute means a real dispute, not a moonshine dispute. Whether there is a dispute as to liability, and if it is proven that there is a dispute, then the NCLT will not go into the correctness of one view versus the other view. It would reject the petition, leaving the parties to their own evidence. This is Section 9 framework. Then, as a part of the process, eventually the process culminates, if all goes well, into a resolution plan. That resolution plan is placed before the creditors, which are known as committee of creditors. The court has held that the commercial wisdom of the committee of creditors is supreme. Which means, if the COC has decided that it is going to accept a certain position or a certain plan, the court is not going to reject that view so long as the plan conforms to the provisions of law. It is not violating any provision of law. So, what is important is commercial wisdom of the COC is supreme. That is not subject to review by any court, not NCLT, not NKT, not the Supreme Court, not the High Court. Commercial wisdom of the COC is not reviewable by any tribunal or court so long as the resolution plan that it has accepted or rejected. In case of acceptance, this is what, this proposition would hold good. It has accepted, conforms to the provisions of law. Meaning thereby it is not saying I am going to kill 50 people to revive the company. Rest of the aspects as to how the capital is being sort of borrowed, or whether the company is to be revived in what manner, how many employees to be retained to be laid off, is not the concern of the court. The court cannot look into the resolution plan or the manner of revival of a corporate debtor. The last principle in IBC that the courts have reiterated is that very often you would find there is a situation where there is a creditor who forgot to lodge its claim with the IRP, the Insolvency Resolution Professional or the Resolution Professional. And the process goes on because it's a time-bound process, and it culminates into a resolution plan. Whether that creditor can come back to say, hang on, you have not considered my debt, please go back, consider my debt, and come up with a fresh or a better plan. the court has laid down the principle of clean slate. Now, clean slate is what it is. We've all used, and at least I did. I don't know how many of you in your younger days have used slate. I don't know whether the kids these days use slate, because I haven't seen my kids using it. But clean slate is what it is. A slate which has been cleaned. So that is the theory that the court has evolved, that in case a debt which has not been lodged, the claim in respect of which has not been lodged in time and has not been considered, is washed off. And this includes, very importantly, this includes government dues. It includes taxes. Not just any debt, but it also includes government dues, it also includes taxes. So, I think I've bored you enough, but good luck to those of you who are going to take the exam, and those who are veterans here. I'm sorry to have taken your time on a day that you could have used more productively.
Sir, excellent.
Yes.
In this particular case, you are referring to SR case only, sir.
SR, Swiss Peoples.
What is the final principle laid down in this particular case by the Supreme Court?
The principle that is laid down is that once the corporate debtor has been, once the resolution plan has been passed and accepted by the NCLT in respect of a corporate debtor, then in the hands of the new management, the corporate debtor comes as a clean slate. Which means anything that may have been written on it is gone. Whatever is not contained in the resolution plan with respect to that corporate debtor is gone, is over. So those debts cannot now be recovered from the corporate debtor.
Washed off all his sins.
Well, sins or not, it is for you to judge and for you to say in your answer. I can only tell you what, according to me, is the position of law.
Sir, what is the normal structure of the answer in the any question? Normal structure.
Very interesting question. My answer to this question would be at least 15 years old. If you want to hear that answer, I will give it to you.
Please.
Please. So, according to me, at least the principle that you must, according to me, you may want to follow is please read the instructions very carefully. And I say that from my personal experience. At least I have lost the art of writing. These have sort of taken away a couple of good things. One is the art of writing. And this exam you have to write. And I was so scared that I didn't read the instructions. I went on to answer every single question. There were, I think, 7 of them. And that was in those days, exam used to be held in June, only in June. And that evening, I was going to go out for my vacation. So I was very eager to go on a vacation. So I didn't read the instructions. I just simply answered all of them. And when I came out of the exam hall, somebody asked me, "So how many questions did you answer?" I said, "How many?" I answered all of them. So they said, "No, you don't want to answer only 4 or 5 of them." So please read instructions because it's elementary. But more than that, look, what happens is this. Nobody, and this is an open secret, your examiner who's checking your answer sheets doesn't have the time or the patience to read your entire answer. Right? You may be a Chetan Bhagat, or you could be somebody else, whoever you read, but the examiner doesn't have the time to appreciate the literature in your answer. What the examiner is looking are those principles. So if in the first paragraph you can use bullet points, which is how I wrote, because I could not write long, but I wanted to sort of convey the point. And how do you convey the point best? You convey it by bullets. Point 1, point 2, point 3, point 4. Once the examiner has seen those 3 or 4 or 5 points that you have to convey, I am sure you have kind of crossed over to the passing side. and thereafter you would write the story line of surely. Of course, it will make sense. But please organize your thoughts in such a way that you put those bullet points the following. So the position of law as emerges from so and so, so and so, so and so, and so and so, in order to give great detail about those judgments, is followed. Crystallize point 1, point 2, point 3, point 4. Then go on to say first, second, third, fourth. Briefly elaborate your points. I think that would hold you in good stead. And if it doesn't, please don't blame me.
Any further questions?